Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
Now, in a week where the nursing dispute in England still rages, warnings abound over voter ID's overwhelming staff, and the Chancellor announces that Britain's economy is back despite a lack of growth in February, we focus on those stories impacting local government law and practice which concern you, Dennis.
Well, Helen, I want to return to the topic of NHS and local authority healthcare integration, which you may recall I covered in the Grapevine podcast for Bulletin 11, published on the 24th of March. I mentioned then the forthcoming Hewitt review, and this has since been released. And for our sector, there are headlines for the role of local authorities, for existing health and overview scrutiny committees, and for local co-developed health priorities. This is all new. Here's more on this. Patricia Hewitt has conducted a review of the oversight, governance and accountability of integrated care systems, constituted of NHS integrated care boards and local authority integrated care partnerships, and all health and care providers who work together in a single system. It proposes greater autonomy to enable ICSs to better prevent ill health and improve NHS productivity and care, matched by renewed accountability. While the Health and Care Act 2022 created the necessary statutory structures for integration and collaboration, legislation alone cannot create the changes in culture, behaviours and attitudes needed for effective and lasting change. The Hewitt report argues that greater autonomy for ICSs, combined with the right support from the centre, greater transparency about performance and robust accountability, will together enable ICSs to succeed. This review sought to hear directly from the system about what changes are needed. The overall direction of the recommendations is broadly supported by ICS leaders. Healthcare leaders across the country are ready to make the changes necessary to embed system working, but implementation will rely on the government accepting the recommendations. Health overview and scrutiny committees, and where agreed, joint committees, should have an explicit role as system overview and scrutiny committees. And to enable this, the Department of Health and Social Care should work with local government to develop a renewed support offer to these scrutiny committees and to provide support to ICSs where needed in this respect. Each ICS should be enabled to set a focused number of locally co-developed priorities or targets and decide the metrics for measuring these. These should be treated with equal weight to national targets and span across health and social care. Now, government specialists will want to look closely at these reform proposals and the new direction of travel that they could take integration in future. Constitutional changes abound in all of this.
Now, coverage of the Welsh Bulletin with a look at what's going on in that region. The Health and Social Care Quality and Engagement Wales Act 2020 came into effect on the 1st of April and uses legislation as a mechanism for improving and protecting the health, care and well-being of the current and future population of Wales. It introduces an organisational duty of candour on NHS bodies, including primary care in Wales, to be open and transparent with people when they experience more than minimum harm whilst using services. Elsewhere, the Social Partnership and Public Procurement Wales Bill is currently at post-stage 4. The bill includes provision for the establishment of a Social Partnership Council, a statutory duty on certain public bodies to seek consensus or compromise with their recognised trade unions when setting their wellbeing objectives and delivering on those objectives, a statutory duty on Welsh ministers to consult social partners, employers and working representatives, and a statutory duty on certain public bodies to consider socially responsible public procurement when carrying out procurement, to set objectives in relation to wellbeing goals, and to publish a procurement strategy. Finally, the Health Service Procurement Wales Bill was introduced on the 13th of February this year, and it's currently at stage 1. The bill includes provision for a disapplication power to enable wealth ministers to disapply provisions of the UK government's procurement bill once that's passed, that would otherwise apply to the procurement of health services in Wales, and a creation power to enable Welsh ministers to develop and implement a new procurement regime for health services in Wales through subordinate legislation. There's quite a number of items flagged in the Welsh Bulletin this edition, and members are urged to look at the Bulletin, where you can find a link to all the relevant news in this region. Now, Dennis, data protection. What can you tell us?
Well, a new data protection bill was published in March, but what precisely has changed? And what are the implications of these changes? And does the UK have a totally free hand in all of this? Here's the detail. On the 8th of March, the UK Department for Science, Information and Technology published the Data Protection and Digital Information No. 2 Bill. If enacted, it will make changes to the UK GDPR, the Data Protection Act 2018, and the Privacy and Electronic Communications Regulations 2003. According to the departmental press release, the bill will result in a new common sense-led UK version of the EU's GDPR and will reduce costs and burdens for British businesses and charities, remove barriers to international trade, and cut the number of repetitive data collection pop-ups online. But this is the second version of a bill designed to reform UK data protection. In July 2022, the government published the Data Protection and Digital Information Bill. This was paused in September 2022 so ministers could engage in a co-design process with business leaders and data experts and move away from the one-size-fits-all approach of the European Union's GDPR. The new bill does not make any radical changes to the previous bill. Rather, it clarifies some points and provides a bit more flexibility in other areas. The main changes are in relation to the definition of scientific research, which now includes commercial activity, the nature of certain recognized legitimate interests, provisions governing automated decision-making, and finally, who is required to maintain records of processing activities. But does the UK have an entirely free hand in all of this? The European Union conducts a review of adequacy with the UK every 4 years. The next adequacy decision is due on the 27th of June 2025. Some commentators have suggested that the changes may jeopardise the UK's adequate status and so impact upon the free flow of data between the UK and the European Union. However, the legislation still retains the UK GDPR's structure and fundamental obligations. Some tinkering around the edges is not really going to have much of an impact, so EU intervention seems highly unlikely. The new bill has been introduced at the first reading stage. The second reading, due to be scheduled within the next few weeks, will be the first time the government's data protection reforms will be debated in Parliament. We expect the bill to be passed in a form similar to the one now published and come into force later this year. We'll report further on this as the bill proceeds through Parliament.
Now, an interesting case on the duty owed by councils under homelessness provisions is set to be heard in the Supreme Court, bolstered by permission being granted to National Charity Crisis to intervene. This is the case of R. Imam and Croydon London Borough Council, which appeal concerns the nature of the duty owed by local housing authorities to homeless people under Section 193, subsection 2 of the Housing Act 1996, in respect of suitable housing and how to enforce the breach of the duty. The facts are that the respondent is disabled within the meaning of Section 6 of the Equality Act 2010. The appellant, a local housing authority, had provided the respondent's housing since 2014, and the appellant accepted that A, the property provided is not suitable accommodation within the meaning of the 1996 Act, and that B, it is in breach of Section 193, subsection 2 of that Act by not offering suitable accommodation. The respondent judicially reviewed the appellant's failure to provide the suitable alternative accommodation, and in the High Court, the Deputy Judge declined to exercise his discretion to award a mandatory injunction to require the appellant to provide suitable alternative accommodation. And in the Court of Appeal hearing last year, this decision was overturned on the basis that the Deputy Judge had wrongly taken into account budgetary constraints imposed on the local housing authority in the exercise of his discretion and in the analysis of the steps taken by the authority to fulfil its statutory duty. Indeed, the Court of Appeal unanimously held that the Section 193 subsection 2 duty is an immediate and unqualified duty to secure suitable accommodation, which was enforceable by mandatory injunction. It was for a local authority to persuade the court why no injunction should be granted, and in trying to so persuade the court, any alleged shortage of financial or housing resources were not relevant factors. This outcome of the Supreme Court case is likely to have significant implications for both local authorities and those living in temporary accommodation. Landmark Chambers are acting pro bono for crisis, and commentary can be found on their website with the hearing due in May. The case citation at appeal, for those who want a more detailed read, is at 2022 EWCA CIV 601. That's definitely a case to watch. Dennis, what's your last item today?
Helen, planning applications in England have fallen to a record low, and the impact upon housing. Experts say developers have been deterred by changes to the planning system brought about by successive Tory governments. Here's the story. Planning applications in England have fallen to their lowest level in at least 16 years, according to figures published recently by the Levelling Up Department that highlight the scale of the country's housing crisis. Local authorities received fewer applications to build new buildings or improve old ones in 2022 than at any point since before 2006, the earliest year for which the government provides statistics. Rough sleeping in England is on the rise for the first time in 5 years, and experts say the lack of new planning applications means the housing shortfall will get worse over the coming years. The figures add weight to a recent study by the Home Builders Federation, which predicted England's house building levels would soon fall to their lowest level since the Second World War. Paul Smith, managing director of the Strategic Land Group consultancy, said, "The uncertainty around where the planning system is heading and what it will look like is a significant contributory factor in this fall. Local housing plans are not being made, and if plans are not being made, then applications will not be submitted and developments will not get built." The data shows that local authorities received 409,459 planning applications in 2022, down nearly 14% on the previous year. The number of planning applications being submitted has been falling steadily since early 2021, and in the last 3 months of 2022, they fell to their lowest level since a brief crash at the start of the pandemic. Now, the proportion of applications being granted has fallen in line with the number that has been submitted. There were 11% fewer applications granted last year than in 2021. And experts say the number is likely to fall even further next year as a result of the drop in applications this year. Experts say that developers in particular are being deterred by changes to the planning system brought in by successive Conservative governments. The Tories were elected in 2019 on a promise to set a mandatory target to build 300,000 homes a year. That target meant local authorities were incentivized to set ambitious housing plans, which in turn gave house builders confidence that their projects would be approved. The fall in planning applications is serious and impacts upon the economic well-being of local areas, upon homelessness and the associated support services and the future of local communities. Is your council addressing these issues? Let us know on the LLG forum page.
And finally, from me, reported in the Local Government Lawyer, Cambridge District Council has confirmed that it has referred its former monitoring officer to the Solicitors Regulation Authority after delaying whilst it considered legal advice. The initial resolution was passed during an extraordinary council meeting on the 14th of February as part of the council's response to a local government and social care ombudsman report, which found fault with how the council had investigated a code of conduct complaint. Now, there's been some recent developments in this matter due to the fact that a recording of the meeting was initially taken down from Cambridge's website, but has now been re-uploaded with the names of some council officers redacted. A spokesman from the council quoted in the local government article said that the recording of the meeting was moved to allow specialist legal advice to be taken due to concerns that the publication of the inappropriate naming of individuals and unsubstantiated allegations made in the meeting could leave the council open to legal action being taken against it. Now, there are no specifics on what is alleged in the referral to the SRA, and of course, LLG cannot directly comment on an ongoing matter, but it's worthy of note, by the way, that it's not only solicitors so affected. See Croydon and the former CEO for commentary on that. All that said, LLG does take a keen interest through its Golden Triangle campaign upon the role of the MO and legal within councils and how difficult and isolating the role of MO can be within some authorities and the impact this has on safeguarding governance. We've been shouting about this for years. Now it seems we have to add SRA referrals to this mix. You should take a look at Dr. Paul Field's Don't Shoot Me, I'm Only the Monitoring Officer Part 2 in the Local Government Lawyer. In the meantime, LLG will be considering carefully the implications of this development. And on that note, you can read more on the items discussed today and many more besides by going to bulletin number 14, available on the LLG website now. So it's goodbye from me.
And from me too.